My last motion, if I may.
Yes, sir.
Your Honor, this is a motion for the court to voluntarily disqualify itself. And if the court would be kind enough to allow me to make my record, I'd appreciate it. This is an appeal to the court's sense of honor, integrity, and to the oath that the court took when sworn into the office that it now holds to support and defend the Constitution of the United States, specifically the Sixth Amendment right to a fair trial, and the Florida Constitution's Due Process Clause in Article 1, Section 9 of the Florida Constitution. The court's order of September 18, 2023, denying Ms. Benefield's request for judicial immunity, on page 26 in the third paragraph, Your Honor, reads as follows. Considering the totality of the competent and substantial evidence admitted during the stand your ground hearing, the state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. Now, had the court issued a neutral order that would have or should have read that the state has met its burden by clear and convincing evidence for purposes of the request for judicial immunity and the defendant's motion is denied, it would have gone on and said whether the shooting was justified is a question of fact to be properly submitted to a jury at the trial of this matter. How can Ms. Benefield possibly receive a fair trial with the conclusion that the court reached in that order? Make no mistake, that order says Ms. Benefield is guilty of the crime with which she is charged. Ironically, we're here this morning to select jurors, and the court is going to instruct them that they are to presume Ms. Benefield innocent of the charges against her. How in the world can we expect that of the jury when the court cannot extend that presumption and honor it based upon what the court's words, not ours, what the court wrote in its order? That conclusion specifically, Judge Whyte, help explain why at this stage the court has, among other things, quashed defense witness subpoenas and told the defense they can prove it some other way when it's our case and our right to a fair trial, and we decide the best manner in which to present our case within the rules of evidence and criminal procedure. Why, Your Honor, has denied Jack O'Keefe from assisting me in the trial of this case, and why the court at the last hearing that we had on its own suggested to the court that perhaps the right action on behalf of the court would be to file, on behalf of the state, would be to file a Daubert challenge. The record of that hearing will specifically note that the defense requested a Daubert challenge in response to the state's motion. The state never did. The court suggested that to the state at that hearing, and lo and behold, the very next day, the state filed a motion requesting a Daubert challenge. As the court knows, according to Florida Statute 3810, you can move to recuse the court based upon demonstrated bias or prejudice. Rule 2.330 of the Florida Rules of General Practice in Judicial Administration likewise provides for the disqualification of the trial judge. Now here's the problem. There's a time limitation. It's imposed in the Rules of Judicial Administration and the case law. And frankly, I missed it. And I missed it because at the time the court entered its order on September 18th, 2023, it was quite some time following the stand your ground hearing, and we were not only focused on filing the appeal, but by the time the appellate court acted and the second DCA denied our motion, I had just missed it. And I take responsibility for that. That, therefore, is why I asked the court, based on its order, to voluntarily take the high road and step aside voluntarily, and give, in doing so, objective recognition to the oath Your Honor took to support and defend our constitutions, which includes, as the court knows, an opportunity for a fair trial by an accused, by an impartial jurist. So, I asked the court to do the right thing. There's no getting around what the court wrote in that order.
Would you like to be heard?
Judge, I would just like to say that at a stand your ground hearing, the court is the trier of fact, and the court does need to make factual findings. And the fact that that is being held against the court, I think, is quite unfair. The court is not the trier of fact in a jury trial. The jury is. There has been nothing in the court's rulings to show any animus towards this defendant. I quite frankly think this is the defendant's MO. This is what she does. When someone doesn't agree with her or a judge does not agree with her, she does a motion to recuse. I feel like this should have been done a year ago if it was going to be done. It was only done at this late time because of the court's rulings did not go in the defense's favor, and this is their last-ditch effort. The state would also say, if the court was inclined to grant this, that we just flip-flop judges right now and start this trial this morning. Thank you.
All right, thank you. Any final thoughts on your motion?
I'm sorry, Your Honor?
Any final thoughts on your motion?
No, sir.
All right, thank you very much.